Michigan has a moderately regulated tenant screening environment where state-level requirements are relatively limited, but several cities, particularly Detroit and Ann Arbor, have enacted or are considering local ordinances that add restrictions. The governing framework includes Michigan's landlord-tenant statutes, including the Michigan Truth in Renting Act found in MCL 554.631 through 554.41, along with FCRA and the Michigan Elliott-Larsen Civil Rights Act. If you're screening tenants in Michigan, what rules apply depends partly on which city your property is located in. Let's start with application fees. Michigan does not have a statewide cap on application fees. There is no state statute limiting what a landlord can charge for tenant screening. Michigan's landlord-tenant statutes do not address application fee amounts, procedures, or refund requirements. Landlords can charge whatever they determine is reasonable. Most Michigan landlords charge between $25 and $50 per applicant. In competitive markets like Ann Arbor and certain Detroit neighborhoods, applicants are accustomed to paying screening fees. In more affordable markets across the state, keeping fees on the lower end helps ensure you don't discourage qualified applicants. Michigan's Truth in Renting Act does affect the overall landlord-tenant relationship by regulating lease provisions and prohibiting certain unfair terms. While the Act doesn't directly restrict screening fees, it reflects Michigan's broader consumer protection approach and means that landlords should ensure their screening fee practices are transparent and reasonable. Criminal history screening in Michigan is largely unrestricted at the state level. Michigan does not have a comprehensive statewide ban-the-box or fair chance housing law for housing. There are no state-level restrictions preventing landlords from asking about criminal history on the initial application. Landlords can inquire about arrests and convictions, can use criminal history in screening decisions, and are not subject to state-mandated look-back period limits or individualized assessment requirements. However, Detroit enacted a fair chance housing ordinance that significantly restricts criminal history screening within the city. Under Detroit's ordinance, landlords cannot inquire about criminal history until later in the application process, after the applicant has been evaluated on other criteria. Detroit's ordinance requires an individualized assessment when criminal history is considered and restricts the types of records that can be used, including prohibiting consideration of arrests that didn't result in conviction and records that have been expunged or sealed. Detroit's ordinance includes penalties for noncompliance, and the city's Civil Rights, Inclusion, and Opportunity Department has enforcement authority. Landlords operating in Detroit must understand and comply with the city's specific requirements. Ann Arbor has been active in tenant protection discussions and has one of the most progressive political environments in Michigan. While Ann Arbor's specific screening restrictions should be verified for current provisions, landlords in Ann Arbor should monitor local developments closely. Additional restrictions are consistently under discussion. Grand Rapids, Lansing, and Kalamazoo have also engaged in tenant protection conversations. Landlords in these cities should stay current on any local ordinances affecting screening. Outside of cities with specific ordinances, Michigan landlords have broad discretion on criminal history screening. Michigan has expanded its expungement provisions significantly through the Clean Slate Act, enacted in 2020. Michigan's Clean Slate Act is one of the most comprehensive automatic expungement laws in the country. Under the Act, certain misdemeanor convictions are automatically expunged after 7 years, and certain felony convictions are automatically expunged after 10 years, provided the individual has no subsequent convictions during the waiting period. The automatic nature of the process means that records are being expunged on an ongoing basis without individuals needing to petition the court. This is critically important for screening. Landlords cannot consider expunged records, and Michigan's automatic expungement means that a growing number of criminal records are being cleared from individuals' histories. Screening providers must filter expunged records from their reports. Landlords should verify that their provider is current with Michigan's Clean Slate Act. If your provider is returning records that have been automatically expunged, you're receiving information you're not supposed to have, and acting on it creates liability. Michigan legalized recreational marijuana, and landlords should be cautious about using marijuana-related records as a basis for denial, particularly for conduct that is legal under current Michigan law. While landlords can still prohibit marijuana use on the premises through lease provisions, using historical marijuana records to deny an application is a separate question that should be evaluated carefully. HUD's 2016 guidance on criminal history and disparate impact applies in Michigan. Detroit has a predominantly African American population, and criminal history policies that disproportionately affect Black applicants face significant scrutiny under federal fair housing law. The Detroit metro area, Grand Rapids, Flint, Saginaw, and other Michigan cities with diverse populations present heightened fair housing risk for landlords who apply overly broad criminal history criteria. Documenting your criteria and applying them consistently is essential. Source of income protection in Michigan does not exist at the state level. Michigan does not have a statewide law prohibiting discrimination based on source of income. Landlords outside protected jurisdictions can consider the source of an applicant's income and can decline voucher holders. However, several Michigan cities have enacted local source of income protections. Ann Arbor prohibits discrimination based on source of income, meaning landlords in Ann Arbor cannot reject applicants solely because they pay with housing choice vouchers or other government assistance. Detroit has also enacted source of income protections. East Lansing and other Michigan communities have discussed similar measures. Outside of cities with specific protections, source of income discrimination is not prohibited by state law. Participation in voucher programs is voluntary for landlords in unprotected jurisdictions. For credit reports, Michigan follows standard FCRA requirements, permissible purpose, written consent, and adverse action notice procedures. Michigan does not impose significant additional state-level requirements for credit report access or adverse action procedures beyond FCRA. Michigan's fair housing protections under the Elliott-Larsen Civil Rights Act, found in MCL Chapter 37, prohibit discrimination based on race, color, religion, national origin, sex, disability, familial status, age, and marital status. The inclusion of age and marital status goes beyond the federal baseline. The age protection means landlords cannot discriminate against applicants based on age, though legitimate screening criteria like income verification and credit history that correlate with age are permissible. The marital status protection means landlords cannot make screening decisions based on whether an applicant is single, married, divorced, or in another marital arrangement. Michigan's Elliott-Larsen Act has been the subject of significant legal interpretation regarding sexual orientation and gender identity protections. The Michigan Civil Rights Commission has interpreted the Act's sex discrimination provision to encompass sexual orientation and gender identity, and recent court decisions have supported this interpretation. Landlords should treat sexual orientation and gender identity as effectively protected under Michigan law and ensure that screening decisions don't target applicants based on these characteristics. The Michigan Department of Civil Rights investigates fair housing complaints and has enforcement authority, including ordering damages, injunctive relief, and civil penalties. Michigan's enforcement environment is moderately active, particularly in the Detroit metro area and university communities. From a practical standpoint, Michigan has a large and diverse rental market with dramatic variation between its major metros and the rest of the state. Detroit has the most complex screening environment in Michigan due to its local fair chance housing ordinance and source of income protections. Detroit's economy has been in a long-term transformation, moving from its historic dependence on the auto industry toward healthcare, technology, financial services, and a diversifying economy. The city has experienced significant revitalization in certain areas. Downtown, Midtown, Corktown, and the Woodbridge neighborhood have seen strong investment and rising rents, while other neighborhoods continue to face vacancy and population decline. Screening in Detroit requires compliance with the city's local ordinances, including criminal history restrictions and source of income protections. The city's predominantly African American population means that criminal history policies face heightened fair housing scrutiny. Detroit landlords must document their screening criteria meticulously and apply them uniformly. The Detroit suburbs, including Troy, Royal Oak, Farmington Hills, Novi, Dearborn, and Ann Arbor, have strong rental markets with different regulatory environments than the city. Properties in the suburbs generally operate under state law rather than Detroit's local ordinances. However, Ann Arbor has its own local protections that landlords must follow. Ann Arbor, home to the University of Michigan, has one of the tightest rental markets in Michigan. The university's massive enrollment creates enormous student demand, and the city's economy, driven by the university, healthcare, technology, and research, attracts professionals and families. Ann Arbor's local source of income protections and progressive political environment create a more regulated screening landscape than most Michigan communities. Screening student applicants with limited credit and rental history is a core competency for Ann Arbor landlords. A consistent co-signer or guarantor policy is essential. Grand Rapids has emerged as one of the strongest rental markets in Western Michigan, driven by healthcare. Spectrum Health and Mercy Health, manufacturing, furniture, and office supply companies, Steelcase, Haworth, and Herman Miller, craft beer and food culture, and a growing technology sector. Grand Rapids market has tightened significantly and rents have increased. The city's growing diversity, including a significant Hispanic and refugee population, means screening criteria must be applied consistently. Lansing, the state capital and home to Michigan State University, has a market driven by government, the university, healthcare, and auto industry operations. MSU's enrollment creates massive student rental demand in East Lansing and surrounding areas. Kalamazoo, home to Western Michigan University, has a moderate market driven by the university, healthcare, including Bronson Healthcare and Ascension Borgess, and pharmaceutical manufacturing. Pfizer and Zoetis have operations in the area. The Kalamazoo Promise Scholarship Program, which provides free college tuition to Kalamazoo Public Schools graduates, has attracted families to the city and affected housing demand. Flint and Saginaw have more challenging rental markets affected by population decline, economic restructuring, and affordability issues. Screening in these communities requires realistic criteria calibrated to the local market. Standards appropriate for Ann Arbor or Grand Rapids may exclude virtually every applicant in Flint. The military presence in Michigan is relatively limited. Selfridge Air National Guard Base near Mount Clemens and Camp Grayling, a National Guard training facility, generates some rental demand, but not on the scale of major active duty installations. The proximity of some Michigan communities to Canadian military facilities, particularly near the Blue Water Bridge and the Ambassador Bridge, creates occasional cross-border screening considerations. College towns across Michigan, including Ann Arbor, East Lansing, Kalamazoo, Mount Pleasant, home to Central Michigan University, Marquette, home to Northern Michigan University, and Ypsilanti, home to Eastern Michigan University, all have significant student rental populations requiring consistent approaches to limited credit and rental history. One best practice for Michigan landlords: verify that your screening provider is current with Michigan's Clean Slate Act. Automatic expungement is ongoing and records are being cleared continuously as individuals meet the eligibility criteria. If your provider is returning automatically expunged records, you're receiving information that shouldn't be on the report. And considering that information in your screening decision creates legal risk. Ask your provider specifically about their compliance with the Clean Slate Act and how frequently they update their criminal record data. Another best practice: determine immediately whether your property is in Detroit, Ann Arbor, or another city with local screening restrictions. Build your screening process around the most restrictive rules that apply to each property's specific location. If you own properties in both Detroit and a suburban community, you need different procedures. Detroit's criminal history restrictions and source of income protections don't apply in communities outside the city. A third best practice, given Michigan's effective protection of sexual orientation and gender identity under the Elliott-Larsen Act, review your application form and screening process to ensure they don't collect information about or make decisions based on these characteristics. Train anyone who handles applications on the full scope of Michigan's protected categories, including the MCRC's interpretation that sex discrimination encompasses sexual orientation and gender identity. Michigan limits the security deposit to 1.5 months' rent. The deposit must be returned within 30 days of the tenant vacating, along with an itemized statement of deductions. If the landlord fails to respond within 30 days, the landlord may forfeit the right to retain any portion of the deposit. The 1.5-month deposit cap provides moderate financial protection, but thorough screening remains the most effective approach to selecting reliable tenants. For the complete guide to Michigan tenant screening laws, visit tenantscreeningbackgroundcheck.com. Subscribe to our channel for every state in our tenant screening law series.